shareholders agreement is not only for multinational corporations. Even if you're a small business company, you will need a shareholders agreement. A shareholders agreement sets out how the startup or an SME should be managed, how it's operated, and what are the restrictions on the different parties, especially where there is any decisions that need to be approved by a supermajority of the shareholders, and also any restrictions on the transfer or engaging in competing business. A shareholders agreement is particularly important to SMEs and startups when it comes to transfer of shares. In terms of transfer of shares, a founder of an SME or a startup would normally require what's called a right of first refusal and a restriction on transfer to be incorporated in the shareholders agreement. What is a right of first refusal? A right of first refusal is the right of the other existing shareholders to consider whether they would want to purchase or not purchase the shares being offered by a potential selling shareholder. Usually in these sort of cases, the selling shareholder would want to sell its shares to a third-party outsider of the company, and the existing shareholders or the founder may not want that to happen. So having incorporated in the shareholders agreement a right of first refusal, the selling shareholder would need to first offer the shares to the existing shareholders of the company to see if they're interested in buying those shares on the same price and other terms as being negotiated between the selling shareholder and the third-party buyer. If the selling shareholders' shares being offered are not taken up by the existing shareholders of the company, then the selling shareholder would be allowed to sell those untaken shares to the third-party buyer. Other than this right of first refusal, there's also another restriction called the restriction on transfer, which is usually a restriction, or more likely a prohibition, of transfer of the company shares to its competitor, because as a founder, you won't want your shares to be held by a competitor. In addition, there is also the confidentiality obligation that a founder would normally insist in a shareholders agreement. What is the confidentiality obligation about? As an investor, you usually and very commonly have access or come across the confidential information about the company, the SME or the startup, which normally includes proprietary information, its business plans, and its operation details. If there is no such confidentiality obligation being imposed on the investor or any shareholder of the company, then probably these shareholders might disclose or divulge such confidential information to outsiders of the company. And such disclosure would cause irreparable damage to the company itself. So it's very important for the founder to insist on having this obligation, especially on the investors. Finally, one other very important provision that a founder of an SME would need to incorporate in the shareholders agreement would be a drag-along right. A drag-along right is the right of the founder when he finds a potential buyer who is interested in buying the entire company. But at the same time, since the founder doesn't have all the shareholders on his hands, there is investors, he needs to have the right to drag the investor shareholders to also sell their shares to the potential buyer. Otherwise, the transaction could not proceed. Of course, details of how these clauses should be worded and what particular wording should be used in these clauses would have to be decided on a case-by-case basis.